Okay, hi everyone. I'm so glad that you can all make it for this evening. Today we're having a presentation on how to apply the contract to bullying. It's a very, very big topic. While we're here, please tell us who you are in the chat, where you're from, and let's have a conversation about this. It's really very important. Faye Moore is our speaker. She's a great speaker, and she's our Director of Contract Enforcement and the University Grievance Counselor. And I know that you're going to enjoy this presentation. So we're going to start off. Amy will read the community norms and practices, and then we'll have Faye get on. Thank you.
Thank you, Clara. Our PSC community norms and practices. Respect for everyone's worth is fundamental to a university and particularly to CUNY, which was founded on principles of inclusion. We commit ourselves to nurture a work environment that honors the dignity of all, is respectful and free from discrimination, harassment, or bullying. And we therefore agree to respect each other's differences and to create a healthy, safe, and rewarding environment that nurtures, challenges, and supports the community. In order for our community to function in this way, it is useful for its individual members to make the following commitments. 1, I commit to conduct that is mutually respectful and not discriminatory, harassing, bullying, or threatening. 2, I take responsibility for my actions and my personal perspectives, recognizing that there may be disagreements with others. 3, I will respect everyone's contributions and honor the roles and responsibilities of all members through my words and actions. 4, I will be mindful and reflect on how I might be using or misusing my power and privilege in my interactions. 5, I will intend to be inclusive and support others with the same respect and compassion that I want for myself. 6, I am willing to be an active ally and upstander by speaking, intervening, or acting on behalf of a person being attacked or bullied. 7, I will seek to understand others and assume best intentions in all interactions. 8, I will seek to understand other perspectives and avoid making assumptions. 9, I commit to listen actively and with compassion at the workplace and in all union meetings. Thank you. And now I'm going to turn it over to Faye Moore.
Okay. Wait a minute. All right. Good evening, everyone. I'm very glad that you're all here. As a staff person assigned to the anti-bullying committee, first of all, it is a great group of people, and many of them are on the call. And we're responding to a crisis because on campus, in office, administrative, student bullying is a problem in CUNY, and we can't walk away from it. We can't act like we don't see it. We can't act like it really doesn't exist because we're in higher education. It is a real serious problem. So tonight, I want to walk you through the parts of the contract that you could use if you find that you or one of your colleagues is being bullied. If we can this is the contract of, this slide is the Contract Enforcement Department. I'm Faye Moore. We have 2 coordinators, Greg Duros, Emma Powell. Those of you that know Emma Powell, yes, she is back and in full force. We also now have Carol Real. She's a full-time adjunct grievance counselor. Our administrative assistant that many of you have spoken to is Stephanie Crowder, and Pete Zweiback is the lone PSC attorney, and the legal assistant is Sharon Tom. So that's who we are. Next slide, please. Before we start to talk about how the contract can address workplace bullying, this slide tells you exactly what workplace bullying is. And it reads, for those, if you cannot see it, workplace bullying is repeated, unreasonable actions aimed at intimidating, humiliating, degrading or undermining an employee or group of employees. Bullying may create risk to all employees' health and safety. Workplace bullying often involves abuse or misuse of power. Bullying behavior creates feelings of defenselessness and injustice in the target and undermines the individual's right to dignity at work. Bullying is different from aggression, which may involve only a single act. Bullying involves repeated attacks, creating an ongoing pattern of abusive behavior. Bosses who are tough or demanding or who set high standards are not necessarily bullies, as long as they are respectful and fair and their expectations are reasonable. If you've ever been in a position that you've been bullied, you can see how this definition can be twisted a lot of ways. Oh, I'm not bullying. I just demand the best of my workers. I'm not intimidating. I just have a loud voice. It's not, I'm not being aggressive. This is just how I am. But meanwhile, the employee or the colleague or the peer that receives the behavior may start stressing out, may start having stomach issues, may start losing their hair, may have these huge headaches that they can't get out the house because this person is claiming it's just the way I am. Or this is how we've always worked. This bullying stuff is new. That's something that we hear in workplace discussions. Thank you, Amy. We will take questions at the end of the presentation. But I want you to take this and have a working definition of what bullying is, so that when you see it, you can name it and you can fight. You can use this definition to guide your fight against it. Next slide, please. Of course, contract enforcement. What do? We file grievances, and there's a number of on-campus grievance counselors on the line. I'm so glad to see all of you. The Article 20 of our collective bargaining agreement covers the grievance procedure. Now, let me just say, since we're here at the contract, our contract does not have anti-bullying language in it, and I'll probably say that more than once in this presentation. What this session is about is using what is in the contract so that you can effectively file actions against people or departments and I shouldn't have said people, against the college and the administration for allowing this kind of behavior to be on campus and, quite frankly, prevail on campus. That's what this workshop is about. What do we have? What can we use to fight back? You are not defenseless if you are subject to bullying. Your union has not left you defenseless. It's not easy. It's not, I will be very honest, it's not quick, but it is a fight back. And sometimes just the fact of knowing that you're going to fight back will make the college recognize the behavior and try to address it. Next slide, please. So this is the language right out of Article 21, and it talks about how we agree to use our best efforts to encourage informal and prompt settlements of complaints. This, everything is not a grievance. For instance, a problem you're having with an individual is not a grievance. It's not subject to the grievance procedure. But this is what the collective bargaining definition is for filing a grievance, any grievance. It could be workload, it could be time and leave, it could be, all grievances are defined this way. A complaint is an informal claim by a grievance is an allegation by an employee or the PSC that there has been a breach, misinterpretation, or improper application of a term of this agreement, meaning our contract, our collective bargaining agreement, or, and this is the key, arbitrary or discriminatory application of or failure to act pursuant to the bylaws and written policies of the board related to terms and conditions of employment. And that's what we have as a tool when we're using the grievance procedure to combat bullying. Next slide, please. The first thing is that unfortunately with bullying, oftentimes people will endure a lot of targeted behavior before they say, maybe I should file a grievance, or maybe I should explore if I have a grievance, or maybe I should just talk to somebody. But in our contract in the grievance procedure, we have 30 business days, 30 business days in which to file. Now, those of you who have been through the grievance process will know that there's also language in the contract about how soon you're supposed to get a decision. Now that gets abused and stretched all the time, but CUNY will throw a grievance out if it is filed in 31 days. So it has to be within the 30 days. So this is important, because if you note behavior, if you or if you just actually have a flagrant violation, or you see one of CUNY's policies that should protect you in the workplace being flagrantly violated, you have 30 business days to file a grievance. What do I mean by that? I just said about 2 minutes ago, there's no anti-bullying language in the contract. However, in the previous slide, it said that we can file a, go back to the previous slide, please, Amy. An arbitrary or discriminatory application of or failure to act pursuant to the bylaws and written policies of the board related to terms and conditions of employment. Policies of the board: equal opportunity and the CUNY policy on equal opportunity and non-discrimination, the CUNY policy on workplace violence, the CUNY policy on sexual misconduct. All of these are, if you file with these bodies and they conduct an investigation and they do something, let's say you're being bullied because of the color of your skin, and you file a complaint with the diversity officer or Office of Diversity and Compliance, and you give them a list of witnesses. Within the 90 days prescribed for the investigation, you get a letter back saying that we found no discrimination. But when you ask for the investigative report, they didn't interview any of your witnesses. They didn't try to reach any of your witnesses. People submitted statements. Nobody read the statements. That makes the investigation improper, and that allows us to file a grievance. And when we file a grievance, we can talk about why this is improper. I gave you 5 names of 5 women that suffered with gender discrimination, and the college chose not to interview any of them, but told me that I was not being discriminated against. That's an improper investigation. The workplace violence, they're supposed to give a report to the president. Well, we didn't think anything violent happened, so we didn't write a report. That's an improper investigation. The college is responsible for not only the investigation part, but the issuing something and then taking action as appropriate. It's not whether they liked how the investigation come out. Did they do a proper investigation? Do they really want to get behind get under what is the real problem? And that's where CUNY fails over and over again. They'll do cursory investigations. They might interview 1 or 2 witnesses, or they'll say, well, you said this happened and we asked him and he said it didn't happen. So we find like that there was no workplace violence. What they're saying is that we don't take what happened to you seriously enough to do a thorough investigation. I encourage people, and I know I'm going to speak on that in a second. I encourage people to reach out to your grievance counselors, your HEO advisors, the central office to file those grievances. Why? We have an old arbitration where it was decided it's not enough to say that you've been discriminated against. You have to show how you were discriminated against. And it sounds kind of simple, but it really isn't. It's very dismissive. It's very dismissive. If you say to me that I feel discriminated against because you keep calling me a girl, but I can't prove that, you meant any harm by calling me a girl, I should have to continue to endure that behavior. That decision is older than some of the people on this call. It's about from, I believe, 1984. And in 1984, we were not as educated. We were not as sensitive as about the way people are treated and the way people are addressed in the workplace. So this 1984 standard is still being imposed upon us today. The way that we combat it is that we have to keep filing. We have to keep filing. I'll get to techniques in a minute. Go to the next slide, please. Next slide. Thank you. There is also something that is an informal procedure for handling complaints, and it is in Article 20 of our contract. And in Article 20, you can have a discussion with the labor designee or the department chair or the dean, and you try to come to some resolution. In bullying situations, sometimes people really don't know how they come across to people. Sometimes they just don't know. So maybe you'll get the person that's just insensitive, not a bully, but insensitive, and you have an informal discussion about that. Or maybe there are two people that just simply cannot get along, and maybe they shouldn't sit together in the registrar's office. Well, in an informal discussion, you can talk about moving people around or having people mutually agree to leave their office space and sit somewhere else. It's not a grievance. You can't grieve, I don't like where I sit. It's not a grievance, but it's reasonable people having a discussion and coming into some kind of conclusion, some decision that people can live with. Marcia Newfield happens to be very good at using the informal conference procedure to protect adjuncts, to stand up for adjuncts. And you don't have to file a grievance, but Marcia is a person that will get a resolution. Next slide, please. Here are the contract violations that we use the most when we are confronting bullying. Article 8. Article 8 is what I spoke about. If we are filing an improper investigation, filing that there's been a violation of the CUNY policy because the investigation was proper, we say it's a violation of Article 8, because Article 8 prohibits discrimination on race, gender, sexual orientation, disability, national origin, religion, or political belief, and participating in union activity. So if you're treated differently because you contacted the union, if you got I actually have a grievance where there is a guidance letter where the dean is giving the person guidance for contacting their union. That's protected activity according to Article 8. So if there's an investigation and they don't do a thorough investigation, or they do a very dismissive investigation or turn it against the person that's filing the claim, that's a violation of Article 8 because you're being discriminated against because of whatever basis that you filed, or it also falls under participating in union activity because you've taken action to protect yourself as a member. Article 15. Article 15 prohibits an unreasonable workload and scheduling for the HEO and CLT titles. And oftentimes the bully or the college will allow the bully to pile work on one person, to give unreasonable assignments to people. For faculty, scheduling people for a class at 10 a.m. and then their next class is at 4 p.m. Okay? There's always they can manipulate workload, and we use that. And what happens is we, as I said, we can't file that it's bullying. But what we can say is that the college is creating a condition for this staff member by giving them an unreasonable workload. They are setting them up to not be able to function, and the college is allowing them to do that. The college's goal is supposed to make sure that every student is sufficiently educated and that their faculty has the time to research and advance the amount of knowledge that they can impart on their students, and that the administrative staff makes the process as easy as possible for the students and the faculty. So they shouldn't be in the business of overloading people, burning people out, dismissing people, giving one person really 40 hours worth of work and the other person gets to have 2-hour lunches. They're not supposed to be in the business of that. Also, what they'll do is they'll say, knowing that someone has a 35-hour work week, they will give them 50 hours worth of work. And when they do the 52 hours worth of work, they will say, well, I didn't authorize overtime. That is abusive, and we can fight that. And in the right context, we can demonstrate that the person is being bullied. Article 18. Article 18 discusses the procedure for evaluations. Everybody, every title gets evaluated in some form or fashion. How does they use the evaluation procedure to bully people? Well, they'll take a negative action against someone, and if the person responds or inquires, they'll say, well, you know, your evaluation conference is coming up, to intimidate them. I have a problem with the way you assigned me a certain type of work. Well, we'll discuss that in your evaluation conference if you can't do it. That's not guidance. Okay, you're entitled to guidance. So the evaluation, even the conference, is only supposed to be one person in there. The person the evaluator should be the person that supervises you, or that person's supervisor if they're connected to your work, and the person being evaluated. That's it. It's a 2-person operation. The only way that it's a third person, a more than 2 people operation, is if either the party says, I don't feel comfortable or safe having an evaluation conference with this person, and then we have to do a settlement agreement in order to get a third party. You just can't say, Amy, come with me to my evaluation conference. Oh no. We have to let CUNY Central know that we need a settlement agreement to allow, because it waives part of the contract, to allow someone to be at the evaluation conference. And it also accounts for the post-observation conference. People have to feel safe when they have these conversations, because oftentimes, even when there's nothing about bullying present, sometimes these conversations are uncomfortable. Sometimes people have a bad year. Sometimes other things outside influences affect the way people perform, and they may not feel safe, or they may not feel like the person understands them. So know that if there's a third party, it's not something to be taken lightly, because it requires a settlement agreement. It requires a settlement agreement, and also that we take the evaluation process very seriously, and we don't like for our members to feel that in this contractual conference that they are subject to being bullied. If we can demonstrate animus in the hearing process, the step 1 or the step 2, we will do that. And the goal is to have the evaluation expunged. But because we don't have anti-bullying language, nothing happens to the bully. And I'm smiling because I just find it ironic that we have to go, that we just don't have it. And I'll speak about the bargaining history at the end, because it could be, it's the way you look at it. We're further along than we were, and we're still working to get further when it comes to bullying language. But for the right now, for the here and now, this is what we have available to us. Article 19 describes the right to access of the employee's personnel folder. Since I've been at the PSC, there have been several campaigns to have people go check their personnel folders. And this is why, because sometimes people come in to work every day, they smile, they're nice to you, they take your phone messages, they make sure that your plants are watered, they do lovely things. Meanwhile, they're stuffing your personnel file with negative information and not telling you. There should be nothing in your personnel file that you have not seen. You don't have to agree with it. The standard is, did you see it? So you don't have to agree with it. You don't have to like it. But if they place it in your personnel file, you should have seen it before it got there. And if you see it, if you go to view your personnel file and it's there, we can grieve to expunge it. So what happens in the grievance procedure? We want to know why Angela keeps putting memos in Faye's file and never telling her. What is the point of that? You know, and then every time Faye applies for a CUNY-wide, CUNY-wide search for a position, you know, she interviews great, but then when they look at her folder, she doesn't hear from them again. Well, why? Why is all that stuff in there? You have a right to know what's in your folder, and you should make it a habit to check your folder at least once a year. Thanks, Pam. Okay, the next slide. Reach out to, this is when you should contact contract enforcement. Again, violations of the collective bargaining agreement. So the collective bargaining agreement is on the website. You should look at it. You probably won't memorize it, but just know the key points. The articles I just talked about, Article 8, Article 15, Article 18, Article 19. And even for the faculty members, I think it's Article 25 that talks about sabbaticals, because sometimes, you know, they'll use things like sabbaticals and fellowships to intimidate people, make people afraid to apply, have people think that they'll never get one. You know, those are the kinds of things that are intimidating behavior in the workplace that we cannot tolerate. Yeah, that's up to the committee. That's up to the committee. We're going to hold questions until afterwards, though. Thank you. Again, CUNY policies, including but not limited to equal opportunity and non-discrimination, sexual misconduct, workplace violence, student complaints. I went out of order on purpose because a lot of people think that once a student makes a complaint, that's the end of it. At the end, we're going to talk about Weingarten rights. You have a right to union representation in any interview that involves, when a student files a complaint, if there's any interview, you have a right to representation. Use your right to representation, because the right to representation comes from your Weingarten rights. The rights under Weingarten is the right for an employee to have a representative when the employee feels it's going to lead to disciplinary action. It does not include supervisory meetings. It does not include supervisory meetings, but it does include if you get called in, say, maybe you're the accused, maybe the person, and this is a tactic that bullies use, they accuse the person that they're bullying of behavior in violation of one of these 4 CUNY policies. But you should go with representation. Never take the position that I didn't do anything, so why shouldn't I talk to them? Never take the position for your own protection. Not saying that you did or might have done anything, but for your own protection. Do not sit down with the Office of the Diversity and Compliance, with the fact finder in a student complaint, with public safety. Don't sit with them by yourself. Now, well, I'll deal with that one with Weingarten. And it's also violations of the CUNY bylaws, particularly Article 9, Section 9.3, because that deals with the duties of the chair. The chairs have a lot of responsibility. They have a lot of responsibility. And almost everything has to happen. They have their hand in everything that happens in their department. But they also have a responsible to run their department. One of the things in Section 9.3 is careful guidance and observation. They can't turn a blind eye when they see this kind of disruption in their department. And it's a difficult position for chairs. No one denies that. But that's what their duties are as chair, according to the bylaws. And if they refuse to address something, if they're the person, they're the perpetrator, they're not giving careful guidance and observation because they have a bias. Next slide, please. Now, it's not as simple as calling your campus grievance counselor, your campus HEO advisor, or the PSC central office to say, I need to file a grievance. It's not enough. You should document everything. Every time, particularly since the pandemic, if you're being supervised or have to work with someone that does everything by phone will not commit anything to paper. Your protection is to memorialize what happened in any meeting or any encounter. Good evening, Lara. It is my understanding that you told me that I will have to work on weekends for the month of December, including the holidays. Now, that's what I heard at the meeting. Now, if that's not what happened, I should expect Lara to respond and say, Faye, you got that wrong. That's not what I said. Or you misunderstood, or whatever it is. But if Lara doesn't respond, that's a response. That is a response. Because when we get to the hearing and they say, well, what did the member say when they spoke to the chair or spoke to the supervisor? Well, the supervisor never committed anything to writing, but this is what the member wrote to the supervisor. That has a lot of impact. That has a lot of impact, particularly when there was no response. Also, do you have witnesses and are they willing to testify? And sadly, people will see a lot of things and it'll bother them. It'll disturb their spirit. But when it comes to taking action, they become uncomfortable as well. And we have to honor that. We have to respect that. The rest of the committee members can talk about other things, other topics we cover, like upstanders and documenting what you saw. But as far as filing a grievance, if you have witnesses, know whether or not they're willing to testify. On the other end of the spectrum, you'd be surprised how many people have quietly observed this horrible behavior. And when you ask them, they say to you, whatever you need. You'd be surprised, but you have to ask. You have to ask. And, we can help you vet the witnesses. What was seen? What was heard? Where was the witness? It can't be, well, I heard, I heard that Clara was saying things about Amy, or I heard that Marcia was going to take Daryl off the schedule. That's not good enough. What was seen? What was heard? Where was the witness when they heard it? When they saw it? Where were they? Because it becomes critical in our grievance presentation. Construct timelines to provide a narrative. I have to say, PSC as a membership is really good at this. They're really, really good at this. If there are changes in supervision, of assignment, of work groups, sometimes people come in new. I also do grievance counseling for people at CUNY Central. And when the chancellor changed, a whole bunch of university vice chancellors came in. And they decided that the people that were not there, that had given their whole careers to CUNY, were not good enough. And they started making it a very unhappy place to work. But you have to be able to demonstrate that. Somebody that has always surpassed expectations needs improvement. Where did that come from? The person's been running surpass expectations of satisfactory for the last 10 years under 3 different supervisors. And then one person comes and says, oh, they're unsatisfactory. We have to explore that. We have to explore that, because that is a sign that the person is being bullied. Now, we can't say the person is being bullied, but we certainly can say they're violating the evaluation procedure because they're not evaluating the total performance. Not if this person's been awesome for 10 years and this person comes and says, they're unsatisfactory. We have to be aware of that. Next slide, please. Email all correspondence from the bully to your personal email. CUNY is not above scrubbing things from a server. They're not. We want to think that they won't do it, but they will. And they have. So email it to your personal email so that you have it, because it's part of the evidence, it's part of the presentation. As again, memorialize all your conversations via email. Whatever it is, sometimes people appreciate it because, they don't remember what they said or they didn't follow up with their own email. So sometimes, it's a useful tool, but for your protection, make sure that you do it. File complaints with all appropriate investigative bodies. When we use Article 8 in the grievance procedure, we have to be able to say that it's been an improper investigation because we can't say because we think so, or what we would like to say is we knew you weren't going to do a fair investigation, because most investigations from the Office of Diversity and Compliance across CUNY are not done fairly, or they're not done to protect the person filing the complaint. They're doing it to protect the college. That the goal of the investigation is to protect the college. So, but you have to be in it. Know that this is a negative exercise. Accept that this is a negative exercise. File the complaint anyway, because absent the complaint, we have no contractual violation. Pay attention to the timeline, as I said before. We can always amend a grievance, we can always withdraw a grievance, but we cannot file later than the contractual 30 business days. So if you file a grievance and then you decide, I really don't want to do this, or I don't want to get put through it, or I got a transfer, I don't have to be with these people anymore. You can say, call contract enforcement and say, I want to withdraw my grievance. There's no penalty for that. There's no penalty for that. And it's okay to say that. Finally, grievances are filed against the college or program. They are not filed against individuals. I know people get frustrated because they can name their abuser. They can name their tormentor. But the grievance process is not the place to get any kind of redress that against an individual. Okay, sometimes people will get mad because I will say, did you call public safety? They didn't do anything. Did you call the police? Because it seems extreme, but the public safety doesn't like NYPD coming on their campuses. And college doesn't like to have that kind of reflection, that kind of behavior reflected onto the college administration. But I would only say that in really, really extreme instances, like physical violence. But remember, we will not find relief in the grievance procedure because Angela has been bullying Amy. We will not find relief in the grievance procedure. We can get relief saying that the college really failed to act when Amy came and said, I'm being bullied by Angela. We can get relief that way. The way I approach the labor movement is justice can be very, very slow sometimes. Most of the time it's slow, but you have to stay in the fight. And sometimes it's hard. I know it's hard. Sometimes it just seems unbearable. But we're not trying to abandon you. We're not trying to act like it's not happening. We didn't deliberately take grievances against individuals out of the contract. This is where we are right now. This is where we are right now. And this is what we have right now. It's a long process. It can be a very slow process, but you have to be in the process. Eventually, we are going to prevail. I am convinced of it. First of all, because CUNY has let this problem fester and grow instead of intervening and trying to diminish it. They've allowed it to fester and grow. So it's no doubt in my mind that one of these days we're going to prevail. But these are the tools that we need from you so that we can support you in the grievance procedure. Next slide, please. Okay, before we go to Weingarten rights, I just want to touch a little on the bargaining history. I saw Sharon Persinger entered the room. There's been anti-bullying demands in the contract since 2017, and Sharon, you can correct me if I got it wrong. Since 2017. In the last round of bargaining, we got the joint letter that the PSC and CUNY would work on an anti-bullying campaign. And there are demands on anti-bullying now. We're not in this position because of a failure of the union to get anti-bullying language. It's not, the letter was the result of a fight. And that's how the fight ended. The fight continues. The anti-bullying committee was formed. We have members coming into workshops. Somebody's going to know these numbers. We had to ask an administrator to leave the meeting today early, and the person left respectfully. But why is that person here? Because they know this is a growing problem, and it's only a matter of time because before it becomes a huge problem for this chancellery. But our job is keep it in bargaining. Bargaining demands on about bullying are being discussed. Keep it in bargaining. Keep using the grievance procedure with what we have. I don't guarantee wins. I guarantee fights. Okay. And sometimes a really good fight wins for the next person. Okay. Wins for the next administrator that tries you. So you have to be in the fight. There is, I want to talk about Weingarten because this is a very difficult subject. I'm saying that up front. This is a very difficult subject. As I said earlier, Weingarten rights are, it comes from a Supreme Court decision, and it said that the bottom line is that if an employee feels like a meeting can lead to disciplinary action, they have a right to representation. And again, it's determined by the employee. When we file these complaints, and I saw somebody mention that supervisors, managers, and department chairs are all members of the PSC. You're absolutely right. Here's the hard part. When these people, these members are called in to these meetings because of a complaint that's been filed, they are entitled to representation because what the investigation can lead to disciplinary action. The people complaining are not entitled to union representation because they are the person filing the complaint. When you're in the throes of this kind of situation, that makes no sense to you. I understand that. But the rights that we have to, everybody is afforded, every member of the union is afforded due process. Just like a public defender, just like legal aid, we can't, in contract enforcement, we don't have the luxury of making moral decisions on who gets representation and who doesn't. By them being members of the union and having to deal with the same administration that allowed that behavior to happen, they get representation. The fault, the weight, the blame belongs on your college administration, not excusing anybody that's bullying that happens to be a member of the PSC. But if you're in a workplace that shows compassion, that treats their workers with dignity, there is no place for a bully to grow. Okay, when people, just Googling Weingarten, thank you. Anyway, what we need to do as a union is to make sure that everybody gets protected. We don't judge. We don't judge. We listen to the person being targeted. We offer support. The committee members are going to talk about some other resources that they've been dealing with. We offer support and we tell them what we can do and what we can't. And again, what we can't do is file a complaint on an individual as opposed to the college. All grievances are filed against the college. We can't file a violation of the anti-bullying language in the contract because our contract doesn't have any. Okay, that will change eventually. But right now, today, we don't have any. And I think I just want to say, rather than sulk or withdraw because we don't have bargaining language, get out there with the bargaining team. Get out there with the CAT team. Talk about this because it's a hard burden to hold on to by yourself when you're being bullied. It's a hard burden, but we're here tonight. You're here tonight. You're going to be at other events. We're going to be out there in the field on campus talking to people. We're all out there because we want a better outcome. And the better outcome, the best outcome is to have direct language on anti-bullying in our contract. I don't know if we're going to get there in this round of bargaining, but like I said about the grievance, we have to be in the fight. And all of us have to be in the fight, regardless of how we feel about each other, regardless of how we feel about how slow or fast things are happening. We have to be in the fight. So what I say to you is we're growing as far as faculty counselors and HEO advisors, and we have one CLT advisor just for now. We're growing as, I guess you would call it, rapid response teams. As far as a grievance procedure, we're growing as first responders, and utilize them, because I will tell you, they are a great group of people. And what makes them great is how they feel about the membership, how they care about the membership, how they have no problem. They have no problem telling contract administration, contract enforcement, we need more of this. We need less of that. We need to address how deans can do this. We need to address how deans can call people in for student complaints and not tell the person that they have a right to Weingarten. We need to talk about how the HEOs are getting overloaded and no one talks to them, and they're telling them that they don't have a right to anything. We need to talk to them. We need to keep pressing on behalf of the CLTs who are overworked and are always overworked. But we got to keep talking about it. Don't hold it in. You know what? I talked about uncomfortable conversations. We can all take an uncomfortable conversation. We can all take an uncomfortable conversation, but let's have the conversation. So with Weingarten, I just wanted to explain to people that these rights are for the person being complained about, not the person filing the complaint. And it doesn't sound rational. It doesn't sound like it makes any sense. But we're a union of due process, and we believe in fairness and due process, not judgment, fairness and due process. And on the question, what happens when both parties need representation? And that has happened, cross complaints. Somebody tries to work out a mediation and one person is severely intimidated. Well, we mix it with the on-campus person, someone from the central office. Sometimes it has to be two people from the central office, but we have to know that. We have to know that in order to address it. So if you're asked to be in a room and you've already filed the complaint and you're past the complaint stage, and they ask you to be in a room with somebody that has been targeting you, intimidating you, harassing you, you call the central office and we will get two people out there. You will not be in there. You will not be alone, because the purpose is to show one union protecting all members, but getting to the root of the problem. It's not enough to just, throw our fists in the air and say, we're union, we're union, we're union. We care about everybody. We have to show that. We have to show that. All unions have to show that about now, because it's the only way we're going to survive. Next. Okay, we can do Q&A. Let's see what's in the chat.